Sometimes the hardest part of the law isn't the big question of guilt or innocence. The fine print about who can ask the courts to take a second look and who gets to review, that is what the Supreme Court tackled in Bowe v. United States. The court said a rule that blocks Supreme Court review of certain permission decisions does not apply to federal prisoners who are trying to file a second request for post-conviction relief under a federal law called Section 22255. And the court also said another rule, one that throws out old claims that were raised before, applies to state prisoner cases under a different law, not to federal prisoners using Section 2255. Justice Sonia Sotomayor wrote the majority opinion, joined by Chief Justice John Roberts and Justices Elena Kagan, Brett Kavanaugh, and Ketanji Brown Jackson. Justice Neil Gorsuch dissented, joined by Justices Clarence Thomas and Samuel Alito, and Justice Amy Coney Barrett joined part of that dissent. The court wiped out the 11th Circuit's decision and sent the case back so the lower court can decide whether Bowe should get authorization under the right legal standard. There's more to unpack in what that means for federal inmates trying to bring a second challenge. Stay with us. 9 Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Michael S. Bowe is serving time in federal prison. On top of his robbery convictions, he received an additional mandatory 10-year sentence for using a gun during his crime. Years after his conviction, the Supreme Court issued new rulings that suggested his gun-related sentence might not be valid anymore. One decision said part of the law used to convict him was too vague to be constitutional. Another decision said that attempting a certain type of robbery doesn't count as a crime of violence under the gun law. Bowe wanted to challenge his sentence based on these new rulings. But there was a problem. He had already tried to challenge his conviction before and lost. Federal law has strict rules about when prisoners can file a second challenge to their conviction. A federal appeals court said Bowe couldn't bring his challenge again because he was repeating an old claim he'd already made. Bowe asked the Supreme Court to hear his case, pointing out that different federal appeals courts across the country were disagreeing about whether these strict rules even apply to federal prisoners like him. Justice Sotomayor wrote the court's opinion, joined by Chief Justice Roberts and Justices Kagan, Kavanaugh, and Jackson. The court made 2 major rulings. First, the court said it had the authority to hear Bowe's case. The government argued that a specific provision in federal law prevented the Supreme Court from reviewing decisions about second challenges. But the court disagreed. The justices explained that this provision appears in a section of law focused on state prisoners, not federal prisoners. The law uses different terminology for state prisoners who file applications versus federal prisoners who file motions. The court said that when Congress wants to close the courthouse doors to people challenging their convictions, it must speak clearly, and it didn't do so here. Second, the court ruled on the main question. The strict rule against repeating old claims does not apply to federal prisoners filing second challenges. The key reason is straightforward. The law explicitly says this rule applies to claims in a second or successive habeas corpus application under Section 2254, and that section deals only with state prisoners. Federal prisoners challenge their convictions under a different section of law. The government argued that another provision connects federal prisoners to these state prisoner rules. But the court rejected this argument, explaining that the connection only borrows certain procedures, specifically how a panel of judges certifies whether a second challenge can proceed, not all the substantive restrictions that apply to state prisoners. The court sent the case back to the lower court for further proceedings. Justice Jackson wrote separately to agree with the outcome, but explain her reasoning differently. She focused on what Congress was trying to accomplish with the law. In her view, Congress wanted to prevent further appeals of proper decisions by panels of judges about whether second challenges can proceed. But in Bowe's case, the appeals court dismissed his case based on a rule that doesn't even apply to federal prisoners. Since the panel never actually performed the proper analysis required by law, the provision preventing Supreme Court review shouldn't apply in the first place. Justice Gorsuch wrote a dissent, joined by Justices Thomas and Alito. Justice Barrett joined the first part of his dissent about jurisdiction. On jurisdiction, Gorsuch argued that federal law clearly says second challenges by federal prisoners must be certified as provided in the state prisoner section, which necessarily includes the provision blocking Supreme Court review. He said the court lacked authority to hear the case and should have used different legal procedures if it wanted to address the issue. He criticized the majority for inventing a requirement that Congress must speak with extra clarity before closing the courthouse doors. On the main question, Gorsuch argued that the rule against repeating old claims does apply to federal prisoners. He pointed to language requiring a preliminary showing that the challenge satisfies the requirements of this subsection, which includes the rule against old claims. He believed the majority's interpretation wrongly exempts federal prisoners from Congress's goal of preventing endless repetitive challenges to convictions. This case revolves around a highly technical feature of federal law governing how prisoners challenge their convictions. Congress created parallel systems, one for people convicted in state court and another for people convicted in federal court. Then Congress added gatekeeping rules to prevent prisoners from filing challenge after challenge indefinitely. But Congress wrote these gatekeeping rules using inconsistent language, creating confusion about which rules apply to which prisoners. The court's analysis highlights three important drafting details. First, different terminology matters. Federal law consistently refers to state prisoners filing applications and federal prisoners filing motions. The court treated this as a meaningful distinction, not just different words for the same thing. When Congress specifically said a rule applies to applications under Section 2254, the state prisoner section, the court took Congress at its word. Second, when one law references another, the scope matters. The federal prisoner law references the state prisoner gatekeeping provisions, but only for how a panel of judges certifies whether a second challenge meets certain requirements. The court interpreted this narrow reference as borrowing only the certification procedures, not every restriction that applies to state prisoners. The court was especially reluctant to read this reference as blocking Supreme Court review unless Congress said so explicitly. Third, Congress's drafting choices reveal intent. Throughout this area of law, Congress sometimes explicitly distinguishes between state and federal prisoners. The court inferred that when Congress mentioned only state prisoners in one provision but not federal prisoners, it did so deliberately. In essence, the legal nuance is that these interconnected laws governing prisoner challenges aren't uniformly applicable across the board. Careful attention to the specific labels Congress used and how different provisions connect to each other determined the outcome of this case. Find us online at 9robes.ai. That's the number 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.